Hello, everybody. It's me, the Grouchy Historian. Now we're going to move into week 3 and some of the most famous court cases decided by the Supreme Court. This week, we're going to look at the issue of citizenry. Who is a citizen? What is a citizen of the United States? And of course, the always controversial topic of racial equality. Okay, so we're going to look at 3 cases this week, all dealing with the idea of racial equality and civil rights. These cases are, of course, the Dred Scott case, the case of Plessy versus Ferguson, and of course the case adjudicated within the 20th century of Brown versus Board of Education. And all of these questions, all of these court cases seek to answer the fundamental question of who is an American citizen, and is America truly a land where all men are created equal, as we read in the Declaration of Independence. Okay, so when I was doing the research for this course and got to looking up these particular cases, it's interesting that now Dred Scott and Plessy versus Ferguson are indeed 2 of the most vilified Supreme Court decisions. They're actually considered anti-canon, which I found kind of amusing, and I'll tell you why in a minute. But again, the idea of judicial precedence, and of course, just history and politics make these cases still relevant today, right? We are still talking about the issue of civil rights and equality and racial justice. So let's talk about these a little bit in the historical context, because of course, as Professor Amar noted in his book that I talk about all the time, the challenge with lawyers is most lawyers don't know history, and most historians don't know a lot about the law. Therefore, they're often studied in a vacuum apart from each other, and you really can't, because whether we like to admit it or not, legal decisions are often decided by the politics and the society and the social construct and the social mores of the day. And certainly we can see that this is true with Dred Scott and Plessy versus Ferguson. So Dred Scott was the case brought in 1854 that when a slave, Dred Scott, was taken from a slave state to a free state and then back to a slave state, and he sued because he said he had been taken through a free state and was therefore entitled to freedom. That's the short version, right? You can dig into that a little more as you do your research. The court, led by Chief Justice Roger Taney, who was a Marylander and a slaveholder, ruled that because Dred Scott was not a citizen, he was a slave who was specifically denied citizenship in the Constitution at that time, that he had no legal standing in court to bring suit, and therefore the suit was thrown out. Now, historically speaking, this would have been controversial enough as it was at the time, because if you've studied American history, you'll know that by the 1850s, particularly the late 1850s, the issue of slavery in America, which had been sort of kicked down the road for, since the signing of the Declaration of Independence and the ratification of the Constitution, was coming to a boil, okay? The acquisition of massive territory, both through the Louisiana Purchase and the Mexican War, basically gave America all of the land that it occupies currently in the lower 48 states. And there was a huge debate going on in the halls of Congress, in the newspapers, in American society at large, of whether all of these new territories would be organized as free states or slave states, right? And there had been various compromises attempted throughout the years to keep some sort of balance in Congress, in the Senate, not the House of Representatives, of course, because by this time, the free states had a significantly larger voting age population. Remember, the 3/5 clause that we talked about early in the first quarter was still in effect. So as the population of free people in the northern states got bigger, even though the slave population in the South increased, they didn't have that same effect on representation in Congress, right? The practical effects of the 3/5 clause. So there was an attempt to sort of try to keep that balance in the Senate. Well, this led to a great deal of conflict over how these states, whether their status as free states or slave states, was supposed to be determined. So how does this get back to Dred Scott? Well, of course, there had been various compromises passed, which hopefully you've studied in your history class. The Compromise of 1820, the Compromise of 1850, the Kansas-Nebraska Act of 1854, all of which were extremely controversial, right? At the time that the Dred Scott decision was passed down by the Supreme Court, we had what was called Bleeding Kansas going on, which was basically a mini civil war between free state and slave state protagonists in the territory soon to be the state of Kansas. So when the Dred Scott decision was passed down that said that slaves were not citizens, they had no standing in federal court, and they never would, that would have been controversial enough. However, Chief Justice Taney went beyond that to basically invalidate all of those compromises, particularly the Compromise of 1820, to say that the Constitution and the property rights inherent in the Constitution said that the federal government had no power to regulate slavery and could not prohibit any slave-owning person for bringing his property into the new territories. This, of course, had the effect of a political match being thrown into a room full of highly loaded powder kegs. And of course, coming a short 2 years after that, the John Brown raid on the Harper's Ferry Arsenal, and of course, the election of 1860. And you can see a very direct path from the Dred Scott case to the start of the American Civil War. So, of course, the Civil War is fought. The Union Army, the Northern Army, wins the war, and we pass the 13th, 14th, and 15th Amendment to the Constitution, right? Which frees the slaves, makes them citizens, and gives them the right to vote. Okay, so now we go through the period called Reconstruction, where we have a brief period of, we call it I guess, a renaissance of political power by the new freed slaves in the South before the election of 1876, and sort of the rebirth of the white Southern Democratic Party leads to what it's called segregation, where you have a separation of the races, right? If you've ever seen pictures of restrooms, restaurants, water fountains in the South from the 1930s, 1940s, 1950s, you will see signs that say whites only and coloreds only, right? This was the way it was in the South at the time. And this came about because of a court case called Plessy versus Ferguson. Plessy versus Ferguson was a case that created the notion of separate but equal, where it could, as long as you had equal facilities between whites and coloreds, as they were called at the time, then that was hunky-dory. Now, when you look at Plessy versus Ferguson, one of the things I want you to pay attention to is there's a Plessy versus Ferguson probably has one of the most famous dissents to a Supreme Court case. And remember, Plessy versus Ferguson was ruled from a vote of 7-1. The one dissenter was a man called Chief Justice John Marshall Harlan. And he became known as the Great Dissenter. He wrote some of the most famous dissents to the Supreme Court, particularly his dissent to Plessy versus Ferguson. So I encourage you, as you're doing your paper research this week, to look up Harlan's dissent to Plessy versus Ferguson. Now, Plessy versus Ferguson was decided in 1892, or 1896, pardon me, 1896. And it was the law of the land until the 1950s. Now, one of the things I want you to think about is when you hear ridiculous statements like super duper precedent. I know I've said this before, but it's such a stupid phrase that I have to keep harping on it. There is no such thing as non-overturnable precedent, right? As we're going to see in our next court case in Brown versus Board of Education, which was decided in 1954. So 58 years 58 years after Plessy versus Ferguson, Brown versus Board of Education said the idea of separate but equal was not really true, and it was not really part of, and should be read into the Constitution. The thing about Plessy versus Ferguson is that as long as you had legal equality, you didn't have to have social equality. Now think about that for a minute. That just is very illogical, but that was the whole basis of Plessy versus Ferguson, which stood for 58 years. Brown versus Board of Education says that is legal mumbo jumbo and nonsense. If you do not have full legal, social, economic equality, and I know we discussed what equality means at the time, but at this particular instance, it was defined as not only equal justice before the law, but equal opportunities in education, right? You did not have Black schools and colored schools, as they were called in the day in the South. You had schools, elementary, junior high, high schools. Brown versus Board of Education had the practical effect of being what's called the school integration effect. But again, you can see a very clear lineage between the decisions reached by the Supreme Court in Brown versus Board of Education and the great civil rights legislation that will come less than a decade later, or more than a decade later, depending upon your point of view. And you can definitely see the effect of Brown versus Board of Education to the rise of the civil rights movement in the South, particularly led by Dr. Martin Luther King, right? This is where they wanted to put, as it were, Brown versus Board of Education to a practical use to pass the Civil Rights Act and the Voting Rights Act of the 1960s. So when you look through these cases this week, okay, what I want you to look at is their effect and their wording on what is equality. What does it mean to have equal opportunity and equal justice for all? That justice is colorblind, right? This is another idea that is debated and misunderstood a lot these days, okay? Justice should be colorblind. It shouldn't matter what your station in life is, what color your skin is. We all deserve equal justice and equal opportunity. But again, there's a lot of debate over what that means. So that's why I picked these cases, because these are some of the cases. Again, Brown versus Board of Education was only decided 60 years ago. 70 years ago now, math, right? That still affect us today and is still argued about today. And again, Brown versus Board of Education, again, is a very important case for setting precedents for later civil rights legislation. Okay, so looking forward to, I'm sure your instructors are looking forward to your papers this week. And we'll see you again next week.